evening. On behalf of Santa Clara County Move to Amend and Human Agenda, I'm happy to welcome you to the Speakers Forum on Corporate Constitutional Rights. My name is Carol, and I'm a volunteer with Move to Amend here in Santa Clara. And that is a national grassroots organization dedicated to passing a 28th Amendment to the U.S. Constitution, establishing that 1, artificial entities such as corporations have no constitutional rights under the U.S. Constitution, and 2, money is not constitutionally protected free speech and may be regulated. So it's going to be an exciting talk. A few logistics to make our evening work very well. The bathrooms are located just to the right as you exit that door. And we have a few officials here tonight, or representatives, I'd like to recognize. And Joseph Nave, staff to Congresswoman Zoe Lofgren. Virginia Holtz, member of the Board of Directors of the Santa Clara County Open Space Authority. And Alex Wara, staff to Senator Jim Bell, 15th State Senate District. Brian Carr from the Sierra Club. And Nicole Navosi from Mike Honda's office.
We have one more in the back, Andre Makapedlak from Wachowski's office.
Austin from Kenson Chu's office. Is there any other official or organization? Yeah.
I'm Rod Sinks. I'm the mayor of Cupertino.
So you'll have an opportunity to ask a question later. We have cards that you can write on, and we'll distribute those kind of as needed. You know, you'll raise your hand later. So we are fortunate to have tonight as our moderator Professor David Yosefan, Santa Clara University Law School. He received his law degree from Harvard Law School, teaches business law and related courses, and is published in the areas of corporate governance and social responsibility. He will introduce our other speakers tonight. Thank you.
Thank you very much. I was honored to be asked to facilitate on this panel, and I'm just thrilled to see so many people come out on a Tuesday evening to have this very important conversation. We are gathered here this evening in an act of civil society. We are presently engaged in an act of self-governance. On a night when the World Series begins, what? We have come out of our homes, out of our places of business, into this public square to deliberate amongst each other, with each other, about some of the most pressing matters that face our republic today. No government authorizes us to speak tonight. No document authorizes us to speak. We hold it to be self-evident that the freedom of speech is among the inalienable rights of all humankind, and that neither King George nor the United States government, not the Republic of California, nor His Honor the Mayor of Cupertino, may forbid us from speaking. Not legitimately. And so we are gathered to query and explore the principled limitations of that legitimacy and to understand the question, or to confront the question, whether that inalienable right does extend, should extend, must extend, or may not extend to corporations. Now, no good and powerful idea was ever more easily made weak and powerless, flaccid, than by being allowed to roam free without confrontation with equally powerful ideas. The surest way to embolden our arguments, to ensure that the rightness of our opinions, is to insist that they be confronted with the most coherent, powerful, passionately argued opposition. And so as moderator tonight, I invite heat. When you invite heat, you risk producing smoke. But unless you are willing to have heat, you cannot have light. So let us risk having heat that we might create light and find our way forward through this most difficult of social problems confronting our republic today. My job now is to turn the occasion over to our four speakers, to very briefly introduce them and allow them to press upon you the urgency of their perspective on this matter. And each of them will speak for about 10 minutes, and I'll just wave at them when it's time for them to shut it down. We hope to engage the speakers in some dialogue with each other, and then most importantly, to engage the speakers in dialogue with you all, your thoughts, your questions, your insights, and proposals in the second half of our program. So with no further ado then, I want to introduce Mr. David Cobb, who I've just had the pleasure of meeting this evening. He is a lawyer, a political activist, who has been passionately engaged in this subject for many years. David, explain to us what is at stake in this question.
Thank you, Professor Yusufan, and to my colleagues who are not here, but so glad that they could join us. I really appreciate your initial framing and will underscore we're talking about the question, should corporations have constitutional rights? The Constitution is the supreme law of the land. It is not about policy. It is not about legislation. It is not about issues. The Constitution lays out the principles of self-government. And this is very important because that document begins, "We the people." Those are hallowed words in this country because they invoke the notion that we collectively are in charge. We are sovereign. King George, which you, Professor, alluded to in your introductions, he wasn't in charge anymore. Our ancestors kicked him out. The king was no longer sovereign. We, the people, were sovereign. We had the authority to rule ourselves. And we were not asking permission to rule ourselves. We were asserting it because it was our right to self-rule. It was our right to self-government. You see, the concept of sovereignty is profound, it is important, but as Professor Yusufan tells us, we are not merely a democracy, we are a republic. And that is important because the experiment known as the United States of America says we are a democratic republic where individual rights are sacred. They are sacrosanct. The government cannot, shall not, does not have the authority to infringe upon the exercise of the individual rights of human beings. And I want to be clear. You see, if you as a human being find yourself in the need to assert a constitutional right, what you are saying is that some law, local, state, or federal, is an illegitimate exercise of the political power, because the government cannot tell you or me or any other human being what we can or cannot say, how we do or do not choose to worship, who we associate with. You see, those rights are human rights. And let me be clear, the United States Constitution does not create those rights. The Constitution recognizes those rights. They are inherent. They are inalienable. These are rights that we have because we're human beings. That, my friends, is very important. And now let's turn to the corporation itself and recognize that a corporation is a social construct. Nothing more, nothing less. It is a tool. It is a powerful tool. Arguably one of the most powerful tools that we've created, because it is the idea of facilitating under law and culture a mechanism to allow groups of people to come together and do things. And this idea of the corporation was something that the founders understood very well. It's not a new phenomenon. Corporations had existed for hundreds of years before the American Revolution. And since we have invoked the founders, let's take just a moment to recognize what it once took in the United States of America to form a corporation. First, your application did not go to a clerk who just rubber stamps it. Your application for limited liability incorporation went to the State House of Representatives, where they debated it and discussed it, and you had to get a majority vote. But that's not enough, because now your application for limited liability incorporation goes to the Senate, the state Senate, where they debate it, discuss it, vote on it. You got to get another majority vote, and that's still not enough, because after a majority vote of the House, the majority vote of the Senate, it goes to the governor, who considers it and has to be willing to sign it. Does that sound anything like a corporate charter today? Of course not. In fact, what did I just describe? The mechanics: a majority vote of the House, majority vote of the Senate, governor signs it. Law. The founders of this country understood that the very creation of a corporation was a political act. A corporation is what it is under law because the state chartering process is a political process. But remember this, we have already established that your individual rights are not subject to the political process. Rights, constitutional rights, are different than statutory rights or privileges under law. Corporations do have rights that are statutory. They have privileges that are established under law. They do not have inherent inalienable rights because they are not human beings. They do not have a heart or a mind or a conscience or any. In fact, I like how that great jurist with whom I often found disagreement, Professor and then Supreme Court Justice William Rehnquist, who said, the creation and the fabrication of corporate constitutional rights strains the, and this is a quote, strains the rationale beyond the breaking point. To ascribe to such artificial entities an intellect or mind or freedom of conscience is to confuse metaphor with reality. At the end of the day, we have to understand that the assertion that corporations have constitutional rights is actually outside the boundaries of the founders' vision of a democratic republic. It is actually a new idea that was created by the courts, and may I say that's called judicial activism. That is where the courts have created a concept that cannot be found within the four corners of the document known as the United States Constitution. You see, Move to Amend, and I dare say Free Speech for People, are pro-business. We are pro-commerce. There is a role, and a very important role, for these powerful tools known as corporations to exist. However, the concept of constitutional rights belongs to living, breathing human beings. And that includes David Cobb, Angela Davis, Rush Limbaugh, and everything in between. Corporations are artificial entities. They can do powerful and important things, but to ascribe constitutional rights confuses the concept. At the end of the day, whether one is liberal or conservative, moderate, Republican, Democrat, Libertarian, or Green, I think that Americans agree that we're supposed to have a democratic Republican form of government. We, the people, can debate policy issues, but the principles of self-government are sacred and sacrosanct. When the court creates a doctrine like corporate constitutional rights, it is our right, and in fact, I assert it is our duty to correct the court, just the way we did when the court told us that women are not people with constitutional rights, as they did in Minor versus Happersett. Just as they did when they told us that no black man has any rights that a white man is bound to respect, as they did in the Dred Scott decision. Just as they incorrectly told us that Jim Crow segregation laws do not violate separate but equal. You see, every time that the court has made such a profound, incorrect assertion about rights, we, the people, have the right and the responsibility to correct the court. And that is what we are doing at Move to Amend. Thank you.
Professor Thomas Jude, thank you so much, of the UC Davis School of Law. Thank you so much for joining us this evening.
Thanks for the invitation. Thanks for the opportunity to talk about this. It's a very important issue, and I really like the opportunity to speak to some real people and not just fellow law professors.
Professor Jude, we begin with the proposition. David Cobb has made a compelling argument that constitutional rights only devolve to human beings, natural people, and that corporations might have statutory rights, but that constitutional rights should never be viewed as applying to them. We begin with the proposition that no argument, as however eloquently made, can be confidently committed to unless it is tested against its strongest adversary. So can you explain to us, before launching any critique that you might desire to, can you make for us the best case for why corporations should be understood to have constitutional rights? What's the best case that can be made for that position?
I'm sorry, I'm not prepared to answer that question.
Okay, can
I'd
you...
be happy to jump in on that.
Yeah, Adam, why don't you jump in, and we'll come back to Professor Jude for a critique.
Yeah, no, sure. It's a very important question when we think about which constitutional rights, if any, corporations should have. I wonder, though, if the problem isn't a question of corporate constitutional rights, or is the problem a couple of decisions by the Supreme Court getting it wrong on corporate constitutional rights? The two most important decisions that I'm thinking of are the ones that have really inspired so much focus on corporate personhood and debate about corporate constitutional rights: Citizens United and the Hobby Lobby case. Citizens United holding that corporations had the right to try to influence elections just like ordinary people, and Hobby Lobby saying that corporations are people with religious beliefs and capable of asserting religious objections to generally applicable laws. These cases, I think, are very much wrongly decided. They were wrongly decided, and they should have come out a different way. I don't want to necessarily take from that case, from those two errors, go so far as to say that corporations should never have constitutional rights. Constitutional rights of corporations are not new. They're not just a product of the Roberts Court, of Citizens United, or even of the modern Supreme Court. The first corporate rights case in the Supreme Court of the United States was 1809. Case involving the Bank of the United States. And it was saying, we, the Bank of the United States, we have a right to sue in federal court under the Constitution. And the Supreme Court held in that case that the corporation did have that right, and the right to sue. The court didn't say that corporations were citizens or people, but it did recognize that corporations would have access to the federal courts to sue and be sued. So people could hold corporations responsible for their wrongdoing, and corporations could hold public officials accountable when they were the corporations were the ones who were victims of wrongdoing. So corporate rights are long-standing, go all the way back to very earliest America. Corporations have steadily gained a much broader scope of rights. In the 1800s, the Supreme Court restricted corporate rights for the most part to questions of property, contract, and the right to sue and be sued in courts. These are traditional rights that are associated with corporation and the corporate form. In the 20th century, we've seen the expansion of other rights to corporations, including the right to political speech, which I think is a mistake. But I don't want to take those mistakes and suggest that corporations should never have constitutional rights. Not only are they long-standing, but they absolutely must have some constitutional rights and constitutional protections. If a corporation doesn't have the right to property, a constitutionally protected right to property, then if the state of Georgia decides to build a freeway through the Coca-Cola factory, the state wouldn't have to pay Coca-Cola a dime of compensation. It could just take that property. That can't be the right answer. If Coca-Cola does something wrong in its process and needs to be criminally prosecuted, presumably Coca-Cola would have the right to due process of law, have the right to counsel by an attorney. We wouldn't allow the government to come in and seize all the assets of Coca-Cola as a criminal punishment without giving Coca-Cola due process of law guaranteed under the Constitution. We wouldn't, in the end of the day, really want to take all free speech rights away from corporations. Newspapers, of course, are formed as corporations. All businesses like to advertise and reach their own shareholders or talk to their own members. If we're going to say corporations have no constitutional rights, it becomes very difficult to protect the rights of newspapers like the New York Times that are really essential to critiquing our government. Well, that said, I think that there are some Supreme Court decisions that have gone wrong. I'm not sure that the answer to those decisions is not changing the composition of the court, the direction of the court, rather than eliminating constitutional rights entirely, which I think is a step too far.
Professor Winkler, is there a principled way to distinguish the New York Times case, where we might understand the urgency of protecting the free speech rights of the New York Times or similar operations from the rights of a Coca-Cola, like you just described, which rights that you alluded to, if it's socially useful to protect their property interests, we could do it through statute. Is there a principled way of distinguishing the New York Times on the one hand from the Coca-Cola Corporation on the other?
Well, I'll just say something briefly, and then I'll turn it over to John, who I think has very eloquently developed a nice answer to this, which I think is a very difficult question. I think we absolutely have to be able to distinguish, for instance, media corporations from other kinds of corporations, and recognize that media corporations have a freedom of the press that would be broader than an ordinary business corporation like Exxon or Mobil. I think that's a common sense, long-standing, traditional distinction that we've made. But I would turn it over to John because John has worked very much on trying to solve what is a very difficult issue in the question of corporate constitutional rights.
Okay, John Bonifaz, can you introduce yourself briefly and then follow up on Professor Winkler's invitation?
Yes, I'm John Bonifaz. I'm the co-founder and president of Free Speech for People, and we were launched on the day of the Citizens United ruling, a white move to amend, to both address the threat of Citizens United posing to the Republic with respect to the influence of big money in our politics, but also the threat posed to our Republic with this extreme extension of the fabricated doctrine of corporate constitutional rights. I certainly agree with Professor Winkler that the court got it wrong in that case, but where I would disagree is the suggestion that this is somehow being defined as a couple of court rulings at the Supreme Court level that got it wrong, rather than a serious and direct threat to the Republic, as David so eloquently stated at the outset. I think before I get to answering directly Professor Winkler's points, I do want to highlight that even since Citizens United, and since Hobby Lobby, for that matter, there have been a number of examples in the lower courts where corporations are making these claims, fabricated claims of corporate constitutional rights to try to strike down public interest laws. So these are not isolated questions that have gone up to the Supreme Court, but rather are part of an alarming trend that really threatens the promise of American self-government of by and for the people. I'll just highlight 4 examples of these kinds of claims that are being brought in our nation's courts today, all of which Free Speech for People has been involved with the amici briefs and pushing back against this fiction. First, in Seattle, in federal court, McDonald's and other major franchise corporations are suing the city of Seattle to try to strike down its living wage ordinance, which is an ordinance that was passed by the city to increase to $15 an hour for workers in the city. And the argument that McDonald's and other franchise companies are making in part is that they have an equal protection right under the federal Constitution, under the 14th Amendment, that's violated by this ordinance. It has a phased-in approach with respect to large franchise corporations versus small businesses, and they're saying because we're not treated the same as small businesses, our equal protection rights as corporations are violated. They have happily, I should say, lost at the district court level, but they're pressing that claim before the Federal Court of Appeals of the Ninth Circuit. Second example is Peabody Energy, where in St. Louis, they claimed also to have equal protection rights that were violated. Their corporation having equal protection rights violated by a citizen ballot initiative campaign that would remove taxpayer subsidies to the fossil fuel industry, namely to Peabody Energy, to redirect those fossil fuel subsidies to the concerns that the people of St. Louis wanted: housing, transportation, so forth. And Peabody Energy went into court, and one of their arguments that they used was that they have an equal protection right that's violated. Monsanto is suing the state of Vermont right now in federal court, arguing that they have a free speech right associated with a new law that the state of Vermont has passed requiring labeling of GMO products in our food. And the people of Vermont want to know whether or not they're buying a product that has GMOs, genetically modified organisms, or whether they don't. And Monsanto's claiming that it should not be forced to reveal this. In other words, somehow the free speech argument now applies to their ability to hide critical information that's necessary to protect the public health. And finally, the National Association of Manufacturers is in federal court in Washington, D.C. for the D.C. Circuit Court of Appeals, and they've prevailed thus far in a claim of free speech with respect to the conflict minerals matter. This is the question of whether or not we as a public have a right to know whether certain manufacturers are getting their minerals from the Democratic Republic of Congo, where there's a war-torn region where warlords are making a profit and having control over those minerals. And that is a real human rights question that's at stake there, and there's a federal law that now requires this labeling, and the National Association of Manufacturers saying that is a violation of their corporate free speech rights of their member corporations. So these are just some examples. There are many others. Citizens United, where we see corporate America trying to make these claims to subvert American democracy, to subvert the promise of American self-government and of, by, and for the people. Now, as to Professor Winkler's important points, you know, I think that we have to always ask the question, whose rights are at stake when we're presented with these examples? So, in the case of the New York Times, there are editors, there are reporters, there are writers, there are readers, all of whom who have each individual constitutional right at stake. And the New York Times can have associational standing to represent their reporters and their editors and show up in court, but we do not need to assign constitutional rights to artificial creatures of the state in order to protect the rights of we, the people, as individuals. In other examples, with respect to property rights, we have to ask, are there shareholders that are involved? Are the owners of the corporation involved? Are the employees impacted in any way? I think what has happened here is we've distorted what the Constitution is supposed to be about. Again, coming back to David's opening remarks, the Constitution is supposed to be about we, the people. Not we, the people, and we, the corporations. Not we, the people, and some corporations. No, it's we, the people. And what has happened here as a result of this fabricated doctrine, that yes, has existed for quite some time, but has gained new currency under the First Amendment. But, Professor Wink was right. It was a doctrine that came long ago and actually became dormant after being resurrected under the Equal Protection Clause, became dormant during the New Deal era. But then Lewis Powell, a corporate attorney who became elevated to the U.S. Supreme Court, famously wrote the Powell memo that never was supposed to see the light of day for the U.S. Chamber of Commerce. He became Justice Lewis Powell, and he became an architect of this corporate speech doctrine, which has led us on the path to Citizens United. But ultimately, this is a fabricated doctrine, has no place in our Constitution. And we absolutely must go down the road of enacting the 28th Amendment that makes it clear that it is we the people, not we the corporations, and that people, not corporations, shall govern in America.
Okay, Professor Chu, I want to return to you now and invite you to place further reflection on these matters on the table for us.
Well, I think that we're all in agreement that the Supreme Court is giving too much legal protection to corporations. The question is what to do about it. Now, I think there is a misconception that the Supreme Court has a number of cases that somehow state that a corporation is a person and a corporation has the same rights as John or Adam or myself. And that's simply not the case. As Adam said, there are some particular places where, in order for corporations to exist, they need to have some degree of rights, like the rights to be free from arbitrary government taking of property. But the court does not give them the same rights as people, as human beings across the board. Corporations, for example, they have Fourth Amendment rights against search and seizure, but they don't have Fifth Amendment rights against self-incrimination. And why is this? And partly, the Supreme Court really gives corporations protection under the Constitution, but it doesn't give them rights per se. It gives them rights in an indirect and kind of subtle way, which actually is much more difficult to solve than simply by denying rights to corporations. Let me explain this. So, in many cases, the court treats a corporation as simply an association of individuals. Now, I'm not saying this is a realistic or accurate thing to say about corporations, to the contrary, but this is what the court will say. And therefore, because the corporation is merely an association of people who put their capital together to do business, then their rights, the rights of the individuals, are the rights that are at stake when we talk about corporate issues in the constitutional issues in the corporate context. So, for example, in the Hobby Lobby case about corporate religious rights, the court said, yes, the corporate quote-unquote person is merely legal fiction, but it was created to protect the rights of the people, the individuals, shareholders, officers, and employees, or associated. And so you see how that leads to the notion then that the religious rights of those individuals should be protected, and they're done so indirectly to the corporation. In the free speech context, the court has an even more complicated, indirect way of using individual people's rights. The First Amendment doesn't have the word person in it, doesn't have the word right in it. The First Amendment speech clause says, Congress shall make no law abridging the freedom of speech. The Supreme Court has said that there's a so-called listener's rights theory of the First Amendment. That the one reason that the court and the Constitution protect speech is not to protect the rights of the person who's speaking, but to protect the rights of the public who listens to it. And there you see how that theory then doesn't require corporations to have any free speech rights. It doesn't require corporations to have the same rights as an individual to come up with an excuse to defend corporate speech through the First Amendment. In Citizens United, the court never said corporations have a right to free speech. They never said corporations are persons. Let me say that again. In Citizens United, the court never said corporations have the right to free speech. What they said was that corporate political spending must be protected in order to protect voters' First Amendment rights to receive political information. I don't necessarily agree with that, but I'm saying this is what the court said. So they did not assert that corporations have the rights of human beings. They're much more. The court is a lot of things, but it's not dumb, right? To say that corporations are the same as people, have the same rights to express themselves as people, that's dumb. The court's not going to say something that dumb. They're much more careful. So far I've just explained this approach where the court uses the rights of individuals to protect the rights of corporations. I'm not defending it. I think I admire its cleverness, but I think it's wrong, and it's wrong in a lot of ways. Primarily because it misunderstands how corporations work. The court wrongly assumes that a corporation is like a little club where all the members decide what it does. That's what you see that in the Hobby Lobby case. And it might have been kind of true in Hobby Lobby because that was a tiny little corporation run by a family, and they all sort of agreed on the same religious beliefs. But in a large business corporation, it's not how it works. The shareholders and the employees don't get to participate in decision making. It's all decisions are made by the board of directors. Yeah. Looking at the speech context, if you accept for the sake of argument that there is such a thing as listeners' rights and listeners' interest in hearing corporate messages, well, the management controls these messages. So the employees and the shareholders, and this is something John kind of alluded to, that their rights may be compromised if the management decides to use the money to support a certain candidate or a certain message. In Citizens United, the court said, well, that's not a problem because shareholders control the corporation through quote-unquote corporate democracy. That's just if you own shares in a corporation, you know you don't control the corporation. And it doesn't even mention the rights of employees, right? Employees don't have even less of a voting right than shareholders do. Even if you believe that the First Amendment should protect listeners' rights, restrictions on corporate speech may be justified in order to protect the shareholders and the employees. So what I'm getting at here is that yes, the court does protect corporations, but it doesn't do it by giving them rights and making them corporate or constitutional actors the way it's being. And that, in fact, makes it more difficult to correct the course that the court is on. I think what you have to do is then think more about what Adam was saying and think about the specific ways in which courts protect corporations and go at those one at a time rather than a blanket approach isn't going to do anything because the court has been too clever to actually say that corporations have the rights of individuals. So for example, a constitutional amendment that said it is permissible to regulate corporate political contributions. That you have to go directly at it in that kind of manner rather than in a more abstract approach of saying corporations don't have constitutional rights.
Professor let me follow up and again ask for a principal distinction. The very reason that many people will join the ACLU and pay their dues to the ACLU or the NAACP, the National Organization for Women, the NRA, is because those organizations, those corporations, have an organizational efficacy and can speak more powerfully when their directors are speaking on their behalf, and the whole group can have a much more potent voice than if they were subject to individual control. The reason that people join or associate through the corporate form is because these associations can be more powerful when not every individual is in charge or has the authority to actually control the instrumentality. So can you you pointed to this as a reason why we might denude corporations of constitutional rights, if I may speak broadly. How can you distinguish that from the associational activity of similarly disparate groups like the NAACP?
Well, first of all, I think maybe you misunderstood my point. Denuding corporations of constitutional rights, my point was that that's misconstruing the question. I think that's not what the question is. I don't think corporations actually they don't necessarily have speech rights, or they don't need speech rights because it's the listeners who are being protected. Therefore, as I said, if you want one way to get at the issue of corporate speech, or corporate speech in terms of political spending, is to have a constitutional amendment that permits, and this is the Democracy for All amendment. This has been introduced in the Congress. Says this basically, that there should be it should be constitutional for Congress to pass regulations for artificial entities that are different from entities than from humans. Now, with respect to your question, legislation can be drafted to treat a business corporation differently from a nonprofit corporation. And this is a fundamental problem in the constitutional jurisprudence about corporations. They never distinguish between nonprofit corporations and business corporations. Citizens United was actually about a nonprofit political organization, but all they said in the opinion was corporation, corporation, corporation. They even talked about shareholders in the opinion, but the corporation at issue in the case didn't have shareholders, a nonprofit. So really they should be considered as different kinds of entities. And as you said, the reason people join the NAACP is to use the power of the organization for speech purposes and for political purposes. That's not why someone buys shares in Coca-Cola. That's not why someone buys shares in Apple. And therefore, those organizations should be treated differently. I think you need to protect the interest that you were talking about, people's interest in associating in order to have a stronger political voice. But doing that does not require protecting the business corporation, because that's not why people associate with business corporations.
Now, Dr. Johnson said that only a blockhead ever wrote except for money. The reporters of the New York Times are writing for money, and those who write books, at least in significant measure, are motivated by money. Let's get David let's get David back in. Is the for-profit non-profit distinction a plausible way of drawing the line between what kinds of activities should have the freedom of speech and which should not?
Professor, let's be clear. Under law already, the distinction between for-profits and non-profits is discussed, debated. In fact, they should be. In fact, I'm sorry?
Not in constitutional free speech law.
Right, so if you'll let me, we'll lay it out. The for-profit and the non-profit are already treated differently legislatively, because that's the appropriate realm of what these artificial entities should do or not do. That's where the distinctions are to be drawn. With all due respect, this concept that on the one hand the court is clever enough not to do this, but somehow is too stupid to misunderstand what a corporation really does, I think that's what's missing the point, Professor. I mean, at the end of the day, the question really is, do the inherent and alienable rights acknowledged by the Constitution apply to these artificial entities or not. And so the distinction around, I want to be clear, nonprofit corporations do not possess nor do they need constitutional rights to do their work. John Bonifaz was absolutely correct when he pointed out the associational rights or standing as lawyers understand. Let's remember, and you know very well, Professor Yusma, the NAACP versus Alabama case, which is seminal in this matter. It was not the NAACP's constitutional rights that were being asserted. And for non-lawyers in the room, this is the case where the state of Alabama, during the height of Jim Crow segregation laws, were attempting to force the NAACP to disclose their list. And we know damn good and well why they were trying to force that to happen. And the court correctly stepped in, NAACP correctly stepped in, asserting the individual rights of their members not to be disclosed. The court agreed that the individual rights, and literally the court said, the NAACP is properly asserting the individual rights. Nonprofits, when they are acting on behalf of the individual rights of their members, are asserting the individual rights of their members. It's not because the nonprofit somehow has been created into something new and different. It is still nothing more than a construct. Nothing more, nothing less.
But now
I'm sorry, I think you didn't understand what I said. I'm not disagreeing with you in any way. I didn't say that nonprofits need constitutional rights. I said that what you cannot dispute, although we all agree that we hate it, what you cannot dispute is that the Supreme Court of the United States has said that corporations, nonprofit and business corporations, are protected in their speech because the court is protecting the speech of listeners.
Exactly, and I'm saying they're wrong.
Well, actually, can I?
The court is right. We all agree that they're wrong. Guess what? They win. The Supreme Court. So what I said is that the Constitution should be amended. This has already been proposed in the Congress, that the Constitution should be amended to expressly permit Congress to do what you just said, to legislate, to protect, to prohibit business corporations from political spending, and that legislation does not have to apply to nonprofit corporations. And then I think we'd all be happy with that.
John, I understand Professor Jude to be authorizing the federal government to shut down the New York Times in advance of an election. Is that what you want?
You ridicule me because you disagree?
No, I'm not. Well, please explain your position. Did you say for-profit corporations could be shut down by the government?
No, I said that you could have regulation of campaign spending.
Okay,
Yeah, but
campaign expenditures.
Campaign spending is not the same as editorials that you write in the New York Times.
Oh, they're not.
It's like campaign spending.
So,
Okay. Can I just jump
Please,
in
go
here
ahead.
though, I do feel like we've got to start with some basic, just accepting where we disagree here. Because Professor Chu, Tom, wants to say that really, this was about listener rights. The Supreme Court majority in Citizens United never said corporations have political speech rights. And that's one view of the ruling. Another way to understand the ruling is to figure out how some of the dissenters viewed it, right? So this was a 5-4 decision. This was not 9-0. And certainly very smart justices who happened to be in dissent didn't see this ruling as merely a listener's rights ruling. Justice Stevens, in his eloquent dissent, made clear that we have to address who are the speakers if there are listeners that are hearing this so-called speech. Who are the speakers? And in this case, obviously, Citizens United is a corporation. The question that the court actually transformed from a technical campaign finance matter into a charter for corporate power was to take this nonprofit Citizens United argument around why they should be able to air this movie on Hillary Clinton and the ads around the movie, and now focused on whether they should sweep away all this precedent, barring corporate money in elections. And in doing so, Justice Stevens, in his dissent, found this to be contrary to what the First Amendment was about and where the court had been on this. And in fact, he said in his dissent, the framers took it as a given that corporations could be comprehensively regulated in the service of the public welfare. Unlike our colleagues, meaning his colleagues on this court, they had little trouble distinguishing corporations from human beings. And when they constitutionalized the right to free speech in the First Amendment, it was the free speech of individual Americans that they had in mind. So starting from the basics, we can try to, assume here that the majority was acting in earnest here and just wanted to claim listener rights, or we could actually look more, further into this and see that actually the dissenters in this looked at what the majority was doing is actually painting corporations as people with free speech, political speech rights. So I don't think we can get off so easy saying, well, really, the court never said this, there's no evidence that they ever said this. There is plenty of evidence, and it's in the dissents, first of all. And then if you go further, it's in the actual majority opinion when they talk all about listeners with the obvious point there have to be speakers for it. Now, Justice Kennedy said in the majority, when he defined corporations, this is another area where, frankly, I'm not going to, use the label stupid, but I do think there's a fair amount of ignorance here in that ruling when the claim is that corporations are simply associations of people. We know that's not true. We know that corporations are state-created entities. We can, all of us, in this forum tonight, can decide we want to set up an association to save San Jose. And we don't have to seek a charter from the state of California to be a corporation. We can just do that and be a voluntary, unincorporated association of people. That's a very different group than if we go to the Secretary of State of California, if we charter ourselves as a California corporation, we then get privileges from the state that the unincorporated association does not have. So when Justice Kennedy says simply that corporations are merely associations of people, either he knew full well that was not accurate in the way to define a corporation, or he was somehow ignorant of corporate law, which I don't really believe, and was painting it wrongly so. Either way, it's actually not an accurate description of what corporations are. So this is, I think, these are some basic disagreements that we have as to what happened in Citizens United, which get to the larger point, which is if we see this as a rogue kind of doctrine that is claiming corporations have constitutional rights that were never intended by the framers, then we see the threat posed to the republic. If somehow we define this as, well, there is no threat because really this is just listener rights, then it's a whole other way of arguing it, which I disagree with.
Well, I didn't say it's not a threat. It's an enormous threat. I'm saying that you have to understand what the threat is. The threat does not. There was an enormous threat to us because corporations are protected by the Constitution. The thing is, the way the Supreme Court has done it is in a very clever and sneaky way, I think. And I think I agree with everything you said, that they use doctrine in a very sneaky way so that what they say, the result, doesn't require them to say something as outrageous as corporations are people. They have the same bottom line. The bottom line, the results, the harm to us as individuals, as members of the democracy, is the same as if they had said that. But if they had actually said that, it would have been pretty silly and it would have been much easier to attack. They did it in a much sneakier way, so it's actually more difficult to dismantle.
Okay, I want to begin to transition our panel, not quite yet, but begin to transition to a conversation with those who've gathered here tonight. I want to give Professor Winkler a moment to respond to the other panelists to wrap up this portion of it, and then hear from the group who can have conversation with the panelists. Professor Jew, I do just want to say most humbly that my intention was by no means to ridicule your proposition, but rather to run up against it, to test its vitality, and ridicule was the furthest from my heart, from my mind. So with that, if, Professor Winkler, could you continue with your, or did you want to respond to what any of the panelists
Sure, happy to respond. And I think, we've pointed out a lot of areas of agreement, of areas where we think the court's gone wrong, and some significant areas too of disagreement. I think what the takeaway that I have from Professor Ju's conversation is that you got to have the right remedy to solve the problem. And I share his skepticism that a constitutional amendment that declares in a sort of blunderbuss fashion that corporations have no constitutional rights, have no constitutional standing whatsoever, really is the right answer. I think that, as I mentioned earlier, corporations should have some constitutional rights. We should have a more nuanced approach of thinking about it than just all in or all out. And that it's even possible that we could spend all this time amending the Constitution to eliminate corporate constitutional rights, and we find ourselves in the problem that Professor Ju is pointing out, which is that the court gets the next case and says, okay, we won't protect the rights of corporations. We'll protect the rights of the shareholders. And the corporation is an association, has associational standing to protect the rights of shareholders. Remember, Hobby Lobby was, as Professor Ju says, was a case that was about corporate personhood, but the logic and reasoning of the case was about piercing the corporate veil, about ignoring the corporate forms and protecting the right of the Green family, the owners of Hobby Lobby. The court said that Hobby Lobby gets an exemption from Obamacare's requirement that healthcare coverage include birth control. Hobby Lobby gets an exemption because otherwise it offends the Greens' religious beliefs. The idea that associational standing is the answer, I think, is more likely actually pointing out what the problem is. The reason why corporations have the expansive constitutional rights they have today is because the court has treated them like associations and has pierced the corporate veil. And when you pierce the corporate veil and you look at the people behind the corporation, well, they're always real people. And that helps explain why we've seen an expansion of corporate rights. So it seems odd to me to sort of rest a remedial argument on the same very logic that the court has used to expand the constitutional rights. I like to think that maybe we need to think about it in a very different way, in a way that can help us better distinguish between corporations and people, rather than asking the court as a matter of doctrine to continue to pierce the corporate veil. Sort of led us to where we are today.
Okay, thanks very much to all of the panelists. I think we have, I think we're more confused than when we started out, which means we're making progress, to my mind. But we've got, it also means we've got some way to go before where we want to be. So perhaps this group can help us to get there. And let's have some questions. So have we written them down, or are we just going to have people speak? What will the...
We will have someone approach in a moment to start reading them.
Okay.
I can speak to my question.
Go ahead.
Professor Ju, you have, I'll stand up so you can aim at me. Professor Ju, you have introduced what to me is a radically new concept. I've never heard of it before, and I don't really understand it. And you refer to it as listeners' rights. I have never heard that even spoken before, but I'd really like to know. I'm not arguing with you about it, but I'd really like to know what that would mean. If there was such a thing, what would that mean legally? I really would like to have some elucidation of that.
Were you able to hear the question?
Yes, I did, and it's a great question. And the reason you've never heard of it is because you're not a constitutional lawyer, because it's lawyer speak. I didn't make it up.
Thank you, I take that as a compliment.
I didn't make it up. The Supreme Court made it up. The Supreme Court has talked about listeners' rights, listeners' interests in many cases. I think it is kind of silly, because what it does is it allows the court to avoid the question that John was saying is the real question. Who's the damn speaker here? The court doesn't have to address that if it says that we're talking about the rights of Adam to hear the message, the rights of John to hear the message, to see an anti-Hillary Clinton documentary. That's their right. So it doesn't matter whether there's a right of anyone to broadcast this. I think that's ridiculous. But it is what the Supreme Court said. And it is radical, but it's not radical that I made it up. It's radical that the court made it up. I think the court actually started it with some good intentions back in the 60s. There were some cases that involved leftist propaganda, and the court didn't want to go out and say that, and particularly propaganda that came from abroad. So the court didn't want to say that a Russian political organization had the right to send pro-communist political material to the United States. So they focused on the right of persons in the United States to hear political views, to prevent the censorship. But you see how that can be twisted and become, quite unfortunately, what we have today, where the court can talk about Adam's right to hear when what it's really doing, as John said, is protecting corporations' ability to speak.
I want to respect the organizer's format, which is to receive questions by card. So I'm going to defer to that process.
I'm Harriet, so I've been a volunteer with Move to Amend for a while.
Mary,
Can anybody, can you hear me?
No.
Shout it out.
So I have some questions. Does the Hobby Lobby ruling provide grounds to break the corporate veil and open up owners and maybe CEOs to lawsuits?
I'll jump on that. I think not, although I think you're right in your intuition that the logic of the Hobby Lobby decision should open up the owners of enterprise to more responsibilities. Let's face it, one of the reasons why people form corporations is to gain protection for their personal assets, to gain the cover and security of the corporate veil. Limited liability, they don't lose the money they invest. It's a very important protection that's helped spur an incredible amount of economic development in the United States. It's a great principle. But the court has ignored the corporate form and the distinct corporate legal status in its constitutional rulings. One of the most interesting briefs, I think, in the Hobby Lobby case was filed by a bunch of corporate law professors who were critics of the expanding rights of corporations. And they didn't want Hobby Lobby to be gaining religious freedom rights. And the argument they made was that actually what we should do is treat corporations like people. And what that meant was that we should recognize that corporations have their own independent legal standing in the law. They are distinct legal entities. They have the rights that are appropriate for that entity and no rights that are others. And one of the things that's important that they pointed out as a matter of corporate law, when you take corporate personhood seriously, it means you don't pierce the corporate veil and you don't look beyond the corporate form and look to the shareholders and give the corporation, like Hobby Lobby got, the religious rights of the shareholders behind it. You separate the shareholders and the corporation. And I thought that was a really interesting and imaginative way of thinking about these corporate rights problems.
If I can I jump in on that for a second? I want to just specify for the welcome non-lawyers that Hobby Lobby is a case that does refer to statutory rights that are granted by the Religious Freedom Restoration Act, that is a federal statutory regime. So that could be changed much more simply, and the Supreme Court is just doing their best to interpret what that statute requires and the rights that that statute provides. So that statute would be much easier to alter than would be the Constitution itself. But then you're still confronted with the principal distinction problem that I've been trying to return to in this conversation, because I frankly am genuinely perplexed by it myself, and am looking for guidance. You know, because if you want to, to my mind, if it's principled to you to refuse to allow Hobby Lobby to claim religious freedoms under a federal statute and exemptions for religious principle under that statute, then you've got to explain why it's legitimate for you to force a Jewish deli to provide food for its customers in a way that the state of California requires it to produce, but that is contrary to the rules of kosher. you've got to explain why the state of California or the federal government could force a Muslim store owner to have lottery machines in his or her bodega in a manner that contravenes their sincerely held religious beliefs that gambling is unpious. If those outfits are organized as a corporation or limited liability company in order to protect those business owners from the debts of its enterprise. So again, I'm searching for principal distinctions on these hard cases, and I ask for the audience or the panelists to weigh in on it.
Well, I think that when we talk about we're struggling to understand it, I'm reminded of Franklin Delano Roosevelt, who, upon considering the Constitution during the Lochner era, said, "The Constitution belongs to the people." And it is not merely, it's not just a lawyer's contract. So these hard questions are things that we have to grapple with. And for me, I return to my opening remarks. The Constitution sets the principles. And almost all of these disputes are going to have to be resolved through a political process where we, the people, grapple with one another, as we're doing now. I'm reminded of Larry Kramer, the professor and then dean, and I think now he's gone on to other greater and bigger things. But in the book, The People Themselves, he reminds us that popular constitutionalism is actually our birthright. That there was a time in this country where we, the people, understood that we were supposed to be actually having these arguments and asserting them and keeping the court in its proper subordinate place. You know, the judiciary is supposed to be the weakest branch. And yet today we have allowed them to basically assert what the principles are willy-nilly, and we're left to flummox behind them. So honestly, Professor, I appreciate that you're pushing us to think about that. And at the end of the day, at Move to Amend, what we're saying is these are political questions that need to be hashed out through the political process. And that the Constitution describes principles, and the artificial entity known as a corporation is what we, the people, will say it will be through our legislative process. And they simply don't have constitutional rights, period.
And can I just jump in?
Yeah,
Sorry,
John,
Tom, you had your hand up first.
Please. Just going back to the original question about the example of the deli and the bodega, I think there is something in the Hobby Lobby case that is potentially helpful. I'm not optimistic about it actually working this way, but they took pains to point out that, as Adam was saying, that it was a small corporation and that the Green family ran it, and the Greens all unanimously and sincerely were conservative Christians. And therefore, they would, as Adam said, sort of look past the corporate form and said, look what an insult this would be to the Greens' personal beliefs if they had to contravene them. And that's like the example then that you gave of the deli owner and the bodega owner. If they are indeed these very small corporations that just happen to be in corporate form but are run really by an individual or a family, then there is this direct insult to the beliefs of the individual. And that is consistent with Hobby Lobby. The scary part about Hobby Lobby, of course, and Hobby Lobby itself said it was only applicable to the small family-owned corporation. But you know in the future they're going to extend it. And they're going to extend it incorrectly to a publicly traded corporation with millions of shareholders who all disagree, don't have the same religious rights or religious beliefs. Right? And that's very different from your deli or bodega. And you can't imagine that. You can imagine then a distinction, right? Where if you contain Hobby Lobby so that it would only apply in these very small family-owned corporations, I'll be okay with that. I'm just terrified that it's not going to do that. It's going to go much broader, and it's going to start. They are going to, in effect, be protecting the religious rights of a publicly traded corporation.
John, do you mind if we get in another question, and perhaps you can reflect further later on? Let's get into it.
Here's one, Professor Winkler. You have said corporation would can't read it. Corporations need constitutional protections. For example, when a highway runs through a Coca-Cola plant, can such protections be provided statutorily?
Oh, great question. And it's a really interesting question. Can they be guaranteed statutorily? Sure, you could pass a statute where either Congress says that any state government that wants to take the land of a corporation has to provide just compensation, or the state could pass such legislation requiring it. That's not the same thing as a constitutional protection, though, because what states will do is when they want to build that highway and all of a sudden taking the corporate land costs an extra $10 or $15 million or whatever that number is, well, then the legislature says, well, in this instance, we're not going to do it. And they don't have to because the legislature writes the statutes. And if they want to pass a new law and say, okay, well, we're not going to provide corporations compensation in this event, then they can. I mean, that's the whole point of constitutional rights, is that they take some things away from the legislature by saying they're secured against legislative interference. I think with regards to corporations, basic property rights should be protected that way. Basic due process rights should be protected that way. Corporations should have the right to sue when someone steals their property. And corporations should have the right to be sued when the corporation steals someone else's property. I think that provides us a basis for understanding corporations do have some constitutional rights. What we should be doing is focusing on arguments that are going to help us and to succeed in limiting the rights of corporations that they shouldn't have, such as the rights to influence our elections and religious freedom rights, as in the Hobby Lobby case.
So I love this question. Can I just jump in here? I love this question. I appreciate it, and I think it goes right to what David and I are trying to say tonight. The fact is that any corporation currently chartered in the United States with any state does not have the right to exist. Doesn't even have the right to exist.
Correct.
So where I live in Massachusetts, if the state of Massachusetts decided it wanted to decharter a particular corporation because it no longer thought that corporation was in the public interest in any way whatsoever, it would have the right to do that, and that would be the end of that corporation. Now, certainly there's processes set up for dechartering and so forth, but at the bottom line, the charter of the corporation is given by the state. It is not something that it inherently has the right to. So if we extend the property-taking analogy that Adam put forward with respect to Coca-Cola, and we can understand that if we want to decharter Coca-Cola, we can. If we want to eliminate the Coca-Cola Corporation, we can, as people in the state where it's chartered, probably Delaware. I haven't looked that up, but that is where many of the biggest corporations are chartered. So I really think we have to move away from this idea that these artificial entities of the state somehow should be seen as having political rights under the Constitution like we the people. We do need to govern over corporations with statutes. That's exactly right. From the questioner's standpoint, we have to engage in governing over corporations, and we have to assign certain privileges over corporations. So limited liability protection, as Adam pointed out, is something that corporations want in order to do business. And frankly, in our view of free speech or people, we think that there would be an interesting law that could be created saying, now that they supposedly have political speech rights to spend money to distort our election process, let's, as a state, remove their limited liability protection if they want to engage in exercising. So they no longer get to have. We can do that if any state has the guts to do it. We could actually do that. And then we'd like to see how many corporations chartered in that state or doing business in that state would actually try to influence the elections in that state, knowing that they no longer have limited liability protection, right? So the fact is that we do govern over these entities, and we need to assert our power over these artificial entities. This is a power struggle. This is a power struggle at the core. And the question is, who is going to govern in this nation? Is it we the people or we the corporations? And when it comes to Hobby Lobby, in that case, ultimately it was a statutorily decided case. It was not thankfully, under the First Amendment where the court ruled. I agree with Tom that the court may be headed in that direction to find it under the First Amendment. But at this point, it's a statutorily decided ruling. And therefore, you know, if Congress wants to change that statute, it can. If it wants to expand that statute, it can. But what that means is fundamentally different than the Constitution, because it means that we, the people, created this statute. We can change it. We can amend it. That's very, very different. Very, very different from saying that the supreme law of the land that has political rights for we, the people, now gets to be assigned to artificial creatures of the state and somehow get equal footing with we, the people, and then get a corporate veto, essentially, over us. A corporate veto over our living wage laws, over our Monsanto, you know, over our GMO labeling laws. I still do not understand, with all the claims that can get made about, you know, the so-called individual rights that might be at stake. It may be, very well be, that after this amendment gets enacted, which I believe it will, in due course, after this amendment gets enacted, that there are some shareholder claims that get made, or individual rights claims get made. You know what, that's the point. If there are individual rights that can be found in a specific case, then let's go ahead and decide that way. But I don't know what that individual right is in Monsanto's claim, that we don't have the right to know whether GMOs are in our food. What's that individual right? What's that individual right in McDonald's claim that living wage law somehow violates a corporate equal protection right? These are not individual rights, and there's no individual right that can be found, and that's what this amendment would do. It would make clear that we, the people, rule in America.
We have a large stack of questions, so I want to make sure we get through some of them. Thanks.
So here's another for Professor Drew. You have introduced an entirely new concept, namely listeners' rights. Can you help me understand what that means legally?
We heard that question, and so let's...
And how do you reconcile listeners' rights with the Amstoy case, also the Vermont case, Newark, Vermont case?
Right, not to speak.
Yeah.
Does that answer?
The Amstoy case, Tom, that's referenced, the case that obviously is the predecessor to the Monsanto claim in Vermont.
Yes.
I'm sorry, for the, I see, for the I was just thinking, so this is an interesting question, because this claims like about the Monsanto speech, this is really about compelled speech, so it's not a listener's rights argument. The listener's rights argument is a little bit harder to make, because the claim isn't that somebody wants to speak, it's that somebody does not want to speak, and they're saying the government is forcing them to. So yes, in this situation, I'm not sure that you could actually use the listener's rights argument. The listener's rights argument actually kind of cuts the other way, would cut in favor of more. And I think this is a good point. I think that actually, I don't know really how the corporation is going to make the argument, you know, of, they'll say the government cannot compel speech, but they can't make it based on the listener's rights argument. Now, the story of listener's rights is a lot more complicated than it made it out, because there's a recent case called Alvarez, in which there was a law that prohibited people from lying about receiving military decorations. And the court there said that even though the person did not have a right to lie, but there was no speaker's right, and the public doesn't really have any interest in hearing lies, so there's no listener's right, the court still struck it down because the court just really thought that the government shouldn't be interfering in speech at all. This is a truly radical decision, and I think didn't get the attention that it deserved. It wasn't clear why this was struck down. But if this is true that the government shouldn't interfere in speech at all, then you see that would apply to the compelled speech stuff too, right? Even if there's no right not to speak of the individual, but it's just a fact that the First Amendment's purpose is to control the government and prevent the government from regulating anything having to do with the exchange of information, then that could actually be a separate explanation for why the Monsanto kind of case, why Monsanto should win. I'm not saying I agree with it. I think it's ridiculous. I think it's horrible. But I can see that argument being made based on the algorithm. But I don't think Elizabeth Wright's argument will carry the day in that kind of case.
Let me just hum a few more bars on that, on the theory of the listener's rights, and then move on and quickly answer another question. Is the idea is that the purpose of the First Amendment serves many purposes. Perhaps it facilitates an interest in individual or collective self-expression, but it also serves a functional a purpose in allowing a free people to organize themselves in an effective democratic form of government. And to do that effectively, we need information and we need ideas that have been tested against bad ideas. And so the listener's interest is in the production, proliferation, and circulation of a robust amount of material in order to effectively exercise the freedoms that we otherwise enjoy. That those freedoms are less effectively organized without the listener being able to receive information. So we protect the speaker in order to serve the listener, is the theory of the listeners. All right, let's move on to the next question.
Now, this question, this person says, clearly it is not necessary to get into the controversy of whether corporations have any constitutional rights in order to reverse Citizens United. So why does MTA do so and gratuitously attract opposition to its proposed 28th Amendment, as now worded?
I think that question is worth hearing again. Can we just take it from the top?
Clearly it is not necessary to get into the controversy of whether corporations have any constitutional rights in order to reverse Citizens United. So why does MTA do so and gratuitously attract opposition to its proposed 28th Amendment, as now worded?
So, because, as I think all four panelists have already agreed, the problem is not merely Citizens United. It is not as if we had a functioning democratic republic on January 20th of 2010, and then one court decision came down and we lost it all. Because I want to be very explicit here. The move to amend national leadership, the move to amend rank and file. I mean, we were 12 people in a living room in 2010. We're 400,000 people and growing every day. We are a mass movement of people who understand that corporations are no longer merely exercising power today. They're ruling us. They are literally assuming the role of government because they have the ability to overturn democratically enacted laws, environmental protection laws, worker safety laws, public health laws, and campaign finance laws. So the fact that, all four of us have already been very clear that Citizens United and Hobby Lobby were wrongly decided cases. But you know what? They're not the only wrongly decided cases. The Women's International League for Peace and Freedom has a 20-foot-long timeline where we can go by case after case after case of examples where the court has illegitimately exercised a power to overturn democratically enacted decisions. And those are political decisions. And, you know, democracy doesn't mean David Cobb wins, sadly. But it does mean that we, the people, are supposed to have a process by which we collectively make those decisions. And the concept of judicial review and coming in and overturning a decision, I do believe there is a role for that. But that role should only be done in a clear and unambiguous finding that some law has infringed upon an individual's rights. For example, Jim Crow segregation laws, or laws preventing women from voting. I mean, we can understand that there is a historic role, and you know what's really interesting? Every one of those that I've mentioned were not originally upheld by the courts. You know the reason that those laws changed? Because people like us got together, had these discussions and debates, built mass movements, and corrected the court when they were wrong. The court was wrong then, they're wrong now.
Yeah.
Want to weigh in on that? Is there a narrow solution that's plausible to Citizens United, or is the broad reform that the amendment of this organization proposes the necessary pursuit?
Well, it depends how you define the problem.
Right.
It really does. If you focus narrowly on Citizens United as being a ruling that unleashed unlimited corporate money in our political process, and that's what you think is the real problem here, then you don't need to overturn the fabricated doctrine of corporate constitutional rights. If, on the other hand, you believe, as we do at Free Speech for People, sharing Move to Amend's view on this, that there are two central problems to Citizens United. One is the unlimited money in our elections that distorts the political process, but two is this dangerous fiction of corporate constitutional rights. Then overturning simply Citizens United will not address that problem. And further, I should say, overturning simply Citizens United to get corporate money out of the process does not solve the problem of the wealth primary, the process of individual billionaires and millionaires dominating our political process. So both of these problems out of Citizens United are larger than Citizens United itself. They're about serious threats to the Republic that need to be addressed with the amendment process.
Okay, that's good.
There's three questions here that I think are slightly different takes on the same question. So one, my concern is that the proposed amendment would not dilute the distorting impact of exceptional wealth. Another is, how should the issue of dark money and unlimited money be addressed? And then this is another way of looking at it. Short of a constitutional amendment, what should we do to limit the oversized power of corporate and political speech?
Can you repeat the first part? I didn't hear the first of the three questions.
My concern is that the proposed amendment would not dilute the distorting impact of exceptional wealth.
Would not dilute the distorting impact of
Exceptional wealth.
wealth.
Can I jump in?
Yeah, please, Adam.
I thought to address this.
Yeah.
So, no, that's a very good question, and it does kind of highlight that for many people, Citizens United is just a stand-in, a symbol, if you will, of a political system in which money has become the chief operating medium. And we feel that our elections are being bought. Turns out that after Citizens United, our elections are not being bought primarily by corporations. Oh, they're trying, and I'm sure they've got much more to spend in their future. But our elections are being bought by super wealthy individuals who will not be affected by the move to amend Free Speech for People amendment. That's not a criticism of the amendment. No amendment can do everything. Although to the extent that people support the idea of reform because they want to retake our political process from corporations, we need to do a lot more than think about corporate constitutional rights. What can be done, remember, and one highlight of this is look who is the biggest proponent of campaign finance reform in today's presidential election. It's Donald Trump. Right? He wants people to give back the money to the super PACs, wants to eliminate the dark money. Why? Because he doesn't need it. Right? So you can get rid of a lot of the problems, the kinds of spendings that we have in our politics, and still have really wealthy people spending a lot of money. One possibility would be either legislation to require better disclosure of corporate expenditures, maybe even better, probably required given the current makeup of the Supreme Court, would be a constitutional amendment. One of the competing amendments to overturn Citizens United would focus narrowly on campaign finance law and allowing Congress to pass reasonable and effective campaign finance laws to restrict the money both of corporations and of the super wealthy.
So I feel obliged to jump in and actually make a point. I know that I trust, John, if I don't say it correctly, you will correct me, but the only difference between Move to Amend and Free Speech for People as it relates to this question around money and elections is actually very tactical. Be clear, the Move to Amend proposed We the People amendment has two prongs. One, artificial entities do not have constitutional rights. Two, money is not constitutionally protected speech, so therefore, Professor Winkler, the Move to Amend proposal would satisfy. In addition, Free Speech for People agrees conceptually with both of those things. They believe you do it with two amendments. So they have two amendments that they're proposing. And I want to be very clear that I absolutely support the language, because the Free Speech for People proposals would affect the same thing that the We the People amendment supported by Move to Men. We disagree that you do them separately, but we both agree, Professor Winkler, that we must address both of those doctrines. Absolutely.
Absolutely. Absolutely. I agree completely on that. We need to address both. And they're not competing amendments, they're complementary amendments. They're
Well said.
on
Well
separate
said.
tracks.
Well said.
Okay. This question, didn't this whole notion of corporate personhood stem from the head note, the clerk in the Santa Clara County versus Southern Pacific case, and that head note has been interpreted as precedent in subsequent rulings?
I don't think that's correct. I don't think that's correct as a historical matter. I don't think it really matters. I mean, the head note, what she's referring to is there was a 1986 case that the opinion wasn't at all about corporate rights. The opinion was actually about a state tax law matter. But the lower court, it had been argued as a corporate rights case. And the lower court had held for had recognized the 14th Amendment right for corporations and said they were persons. And so in the head note, the Supreme Court says, this is not a thing. Corporations are recognized as quote-unquote persons under the 14th Amendment. But we're going to talk about the state tax law issue to decide this case. Now the question is, wait a minute, did Professor Ju just say that the court doesn't call them persons? Well, if you look at the lower court case that was referred to in the head note, the lower court said corporations are persons under the 14th Amendment because they are simply groups of individual persons who have 14th Amendment rights. And then later Supreme Court cases explicitly said this. There's a whole bunch of cases later in the 1800s that where the Supreme Court specifically said corporations have the rights of quote-unquote persons under the 14th Amendment because they are groups of individual persons under the 14th Amendment. And as I said, I don't think that's correct because individual persons don't actually run corporations like a little club. But that's what the Supreme Court said. So the Supreme Court personhood doctrine comes, as I said, from this mistaken notion that a corporation is just a group of individual people. But it doesn't actually depend on any one single case because there are multiple different cases where the court said it.
This discussion has been all about the rights of corporations. Shouldn't at least equal time be given to the rights lost by people when corporate rights are given precedence?
Yes.
Next question.
Well, let me say a word about that this goes back to fundamental views of the First Amendment, that the justices who decide Citizens United have this view of the First Amendment that more speech is always better, and this is again the sort of listener's rights perspective, which is that how could it hurt to have more speech? If you don't like what Citizens United has to say about Hillary, say something else about Hillary. And that the solution to bad speech or misleading speech is always more speech. And that is a hallowed tradition of thinking about the First Amendment, but it is not realistic in the sense that it does not take account of the fact that we human beings are not unlimited creatures. We have limited cognitive capacity, we have limited time on Earth, we have limitations in what we can physically see and consume. And so there is a listener's rights view that would sanction the restriction of speech in service of the listener being better able to hear an array of speech. And so that might be a kind of speech that is drowned out, that it's simply not the case that if a corporation or a powerful individual can speak loudly or even eloquently and thus occupy the field of speaking and use up all cognitive capacity and all time, then other speakers who might have spoken more meekly, less eloquently, or less loudly, simply don't get heard. And so those are the individual rights that you might say are being compromised or left out by a view of the First Amendment that robustly protects powerful speakers.
So we're down to 2 more questions here. This one is, why not organize agitators and shareholders groups and employees to agitate from within corporations? Don't employees and shareholders have a say?
So, I guess as somebody who considers myself not an activist but an engaged citizen who happens to have a law degree, I'll take a crack at that question and say it this way. I think that we, the people, should be using every tool available to us to create a functioning democratic republic. I think that we should be engaging at the local, state, and federal level legislatively. I think the amendment process is something that we should critically be doing. I myself have been arrested at shareholders meetings at ExxonMobil, exercising nonviolent civil disobedience as a way to actually try to assert and affect change. So I really do believe in using all the tools available. And the reason that I have put my shoulder to the wheel and put so much of my time into the amendment process is because of my belief and my understanding that it is the supreme law of the land. And if we are going to actually facilitate the creation of a just, democratic, ecologically sustainable, free society, we're going to have a constitution that actually recognizes those rights, and the court has illegitimately interpreted that document, and it's supposed to be our document and not theirs.
I think it is important to use, as Mr. Cobb just said, to use every available tool, and I think shareholder activism is a potential tool, but it's not a very strong tool.
Right.
So that's why you do need the law. You need the might of the state to come down with both feet on this, because if you think of what do shareholders really want, I mean, the vast majority of shareholders want to make money. They're not that interested in it's a minority of people of do-gooders like Mr. Cobb who are going to use their shareholder power to try to make the world a better place as opposed to try to make more money. So I think to fix these things, shareholder activism alone just isn't enough, even though it can be helpful.
There's one more question for Professor Ju, which we've sort of talked about it a little bit, but given the Supreme Court's sneaky ruling, how best to make change to achieve goals of stopping corporate moves in the political arena?
Well, sorry, was there more to the question?
That's it.
So again, I think, like John said, it depends how you define the problem. I guess more of a pessimist, less of an idealist than Mr. Cobb or John, and I would like to would think about taking small steps. And so, for example, to have the part of the MTA amendment or the separate amendment of that John's group, Free Speech for People, suggests, to say that money is not speech. Or separately, the other thing that I talked about that has been discussed about having separate regulation of artificial entities' participation in the political process. These smaller steps, are, with respect to the Monsanto question that John talked about, and address the question of whether compelled speech rights are available to corporations. So, piece by piece approach is an alternative to the more sweeping.
I'd like to make one comment about the money is speech, as we've got about 14 minutes left, so might as well throw a wrench in the works here. I want to probe this question of money is not speech, which is a part of one of the amendments that is under review. If money is not speech, then that is meant. The purpose of that is to license government to restrict the use of money without concern that doing so would run afoul of First Amendment principles. Well, I look at this banner behind me, and it's a beautiful banner, and it's expressive, but if it took money to produce it. And if the government could say, you can talk about move to amend all you want, but no money shall be spent in the production of flyers or banners or television ads or movies about the importance of amending it, then that power to control money is at the very core of the effective use of the effective deployment of them. A professor, I think it's Eugene Volokh, explains this point by saying, yes, money isn't speech, but money isn't abortion either. And so if you think that reproductive rights are an important constitutional freedom, then you would be loath to say, but since money is not abortion, the government can say, have all the abortions that you want, but no money shall be spent on abortions. Clearly that would interfere with the fundamental operation of that right. And so to my mind, and I'd love to be corrected with the idea, I really genuinely would like to be corrected, the idea that money isn't speech would interfere with the very core of the right.
I'm happy to correct you.
Thank you.
I think what's happened here since Buckley v. Vallejo, the 1976 Supreme Court ruling that equated money with speech and set us on this course of unlimited campaign spending, is that we have been living under this false perception that the way to look at this is whether money equals speech or money does not equal speech. The fact is that regulating money in the political process is a form of regulating the manner of speech. So if you have a lot of money to spend, you're able to speak very, very loudly. If you have hardly any money to spend, you can hardly even whisper. We regulate the manner of speech, the time of speech, the place of speech all the time. It must be reasonable under the court's jurisprudence in this area, but we do it all the time. So for example, you cannot stand right at the polling booth where somebody's voting to urge them to vote for X candidate or Y candidate. You have to stand outside the polling place, a certain distance from the door, and that is considered to be a reasonable regulation on the place of speech. It's not on speech itself, it's on the place of speech. Similarly, in Kovacs v. Cooper, a 1949 Supreme Court ruling, the court made it clear that you could not, in fact, take your sound truck, in this case it was a Union sound truck, and go down every street and drown out everybody else's speeches. There was no First Amendment right to drown out others' speech. The ordinance at stake in that case, the Trenton, New Jersey ordinance that limited the use of the sound truck down every 3rd Street, was upheld by the U.S. Supreme Court on the grounds that it was a reasonable regulation on the manner of speech. So no one has the right under the First Amendment to drown out other people's speech. Yet what has happened under Buckley v. Vallejo and the cases that have followed is when it comes to campaign money, campaign finance, political money in the political process, we somehow have tossed aside that whole area of jurisprudence on reasonable regulation of time, place, and manner of speech, and we now have equated money with speech and somehow said that you can spend unlimited amounts of money no matter what. And that has effectively allowed the very rich in our society and now corporate entities to drown out the ordinary citizen speech of those who do not have large sums of money. We need to return to that basic idea that no one has the right to drown out other people's speech, and that we can in fact regulate on a reasonable level the manner, time, place of speech. And that is what the We the People amendment that Move to Amend is pushing for, and the Democracy for All amendment as one of the amendments that we're pushing for. That's what effectively would allow for states and Congress to set reasonable regulations on the manner of speech so that we have a level playing field, and that no matter how rich or poor you may be, you are treated equally in the political process.
So, as John said, like John said, you can only have reasonable limitations on time, place, and manner. So, as you said, if you said you can't spend any money on making banners, that's not a reasonable limitation. But if you put some kind of a cap, or require, for example, public financing of elections, those are reasonable limitations. Banning is not the same as limiting. And in fact, the whole idea of drowning out, as John said, we've abandoned this notion that we can reasonably limit people's ability to drown out. And guess what? That is brand new in Citizens United, because Citizens United overturned the previous case called Austin from the 80s that said you can't use lots of corporate wealth to drown out other political voices. That was the Supreme Court said that was the law for 20 years or 15 years before Citizens United. So it's not a crazy idea. The Supreme Court once used to be on board with it. It's not that long.
Well, I think there was one more question.
One more question. Couldn't each state amend or interpret its state constitution to grant constitutional rights to corporations and artificial entities? Is there anything a federal constitutional amendment could do to prevent this from occurring?
Professor Winkler, you want to weigh in on that one?
Well, I don't think that anything in the current amendments would prevent a state from interpreting its own state constitution or providing as its own matter of statutory legislation expanded rights for corporations within that state. I could be wrong about the scope of the amendments, but that's my understanding of their scope. And I would imagine that most states probably wouldn't try to increase the rights for corporations. There might be a few who would be opposed to this constitutional amendment. But nonetheless, I do think that, even having this debate, there's going to be those states probably and those political forces that want to protect corporations. But one of the things that's unusual about this debate is that the ideas and the principles do cross the usual red state, blue state boundaries. That opposition to corporate free speech rights to influence elections is very broad. Citizens United cases opposed by overwhelming majorities in red states and blue states. And that gives me hope that if we are going to go the route of a constitutional amendment, there might be really a political will there to build on so that we can have a successful process to amend the Constitution. And even if we don't, a very important and educational discussion that hopefully will lead more states to take seriously their ability to restrict corporations than many states currently do.
I think if we've come to the close of our questions, I'm going to turn it over to the organizers to close out the session, but I just want to say a word of thanks to the panelists and to the crowd.